So, thinking about Virginia's talk, I guess I'm living up to a stereotype here. English bloke quoting Latin. How much more of a stereotype could that be? So the theme of this first few slides is, are there things that you can do for your client to protect your client, context of M&A arbitration, cross-border, that might that might achieve peace? I think that the answer to that is probably yes in many disputes. As we know, the disputes, if you get involved in a dispute, can be absolutely brutal, enormous distraction for your executive leadership, can be very expensive, outcome almost always necessarily uncertain. So, I hope your eyesight is better than mine, because I can't actually read any of that, but I will do my best to walk through it. So, as we know, private negotiated M&A transactions in a cross-border context usually structured in one of three ways: merger, stock equity purchase, or it could be an acquisition of assets. So I'm going to try and simplify this by referring only to a sale and purchase agreement, the SPA. I'm not going to worry about mergers or asset acquisition in that sense. What are the main elements of a sale and purchase agreement that you might expect to see in a cross-border M&A dispute? Well, the first one is, I guess, pretty clear to everybody. Warranties and representation, so what the seller tells the buyer about the target company. It could be about things like financial statements, material contracts, title to assets, etc. Then price. I'm going to come on to the more specifics of the two methodologies a little later on through this, when we look at some practical things we might want to do. But there are really two ways, or two mechanisms by which the buyer would pay. The purchase price will be determined for the target. And the first is the, I guess, conventional sort of completion accounts approach, where the buyer is paying for the actual level of assets and liabilities of the target assessed at completion. Final price for the target company is not going to be known until after completion, and therefore there needs to be some post-completion mechanism for determining the purchase price. So that's the first method, the completion accounts approach. Second one, probably familiar to most or all of you, the locked box approach. So I guess with some exceptions that typically are called leakage, the parties under the locked box approach will agree a fixed equity price for the target. They do that by using calculations that are based on historical balance sheets for the target. And the key thing about that is that the balance sheets are prepared before the date on which the parties will sign the SPA. And then just moving down this slide, I think that says indemnification provisions. I should have brought my glasses. Thank you. Please, you can do this bit as well if you like. Indemnification provisions. So the sale and purchase agreement will likely include indemnification provisions. Of course, where the buyer knows about something, but it's before the deal closes, but it still wants protection, may want an indemnity. Where a damages claim wouldn't be an adequate remedy for the breach, may want an indemnity. And then lastly, post-close covenants, so confidentiality, non-compete, non-solicitation. Okay, so far so obvious, I suspect. Excuse me. The didn't go forward. It did. It works. Okay, great. So another quick bit of orientation. So what are some of the core elements that you'll find in a cross-border M&A dispute? Typically the actions are brought by the buyer. Of course, the actions can be brought by the seller, and many times are, but typically by the buyer. And that's really what I'm going to focus on. The actions are typically brought post-close, so after the parties have signed the sale and purchase agreement, they've closed the deal, and the shares or the assets have been transferred. And then the third bullet here is, I guess, really the essence of all of this, that there were things that were relevant to the deal that the seller didn't tell the buyer about the target, or that the seller or the buyer may think the seller misrepresented, or I guess otherwise were inaccurate about the target. And as a result of those things, in this kind of claim, the buyer's going to be saying, well, seller didn't give appropriate disclosure. The result of that is that we paid too much for the target, or that we didn't get what we paid for. We didn't get what we thought we were getting, and that's because the seller misrepresented the position of the target to us. So what does the buyer do about it? Well, oftentimes it's recourse, oftentimes it's to bring a legal action, as we know, and that may very well be through an arbitration agreement. Quite often, as we know, the buyer will have to act fast. It may be time barred under the contract if it doesn't act fast. The arbitration agreement will have a general dispute resolution clause in it, as we know. There may be a conciliation clause, so the parties are required by the conciliation clause, if it's mandatory, it could be voluntary, to approach, it's like stage one of an escalation procedure, I guess, to use conciliation proceedings before anyone rushes off and files an arbitral claim. There might be an expert determination clause, and there may very well be one of those, as you know, in this context, where the issues like the valuation of closing accounts is put in the court of an independent accounting expert. Very often, though, despite all of these conciliation and expert determination provisions, the parties are going to find themselves unexpectedly on the opposite sides of the table in an arbitration. So, the very last bit of orientation, did that work? That worked. And then I'm going to move on to some practical things, thoughts. So what are the typical types of M&A dispute, at least in my experience for what it's worth? Well, I already mentioned claims, or I mentioned warranties and representations. So in most M&A arbitrations, cross-border M&A arbitrations, there are going to be claims by the buyer based on contractual warranties and representations. Second point, purchase price adjustments. So, again, as we'll know, this is a very common theme of these kind of disputes. So this assumes, remember I mentioned there were these two valuation mechanisms. This will typically assume that it's the first of the two that's used and specified in the arbitration agreement. So there's a completion accounts approach for determining the final price that the buyer will pay, and not this locked box mechanism. These are ultimately pricing terms, and you don't need a breach of warranty or representation to found a complaint based on a price issue. Those disputes can stand alone of those points, but purchase price adjustments are a very fertile area for disputes in this context. Thinking about it, it's not that surprising if you think about what happens with the completion accounts valuation. So you're going to have the buyer preparing a closing date balance sheet, which will have the actual achieved working capital specified in the agreement. And then there'll be a comparison made between that actual achieved working capital and a target working capital amount that the parties will have already put in the sale and purchase agreement. So the buyer and seller are actually ultimately going to agree on the numbers. That may not always be something that is easily done. So you can have situations where, as you know, where the seller may disagree with the buyer's calculation. The seller may think that the buyer has manipulated the earnings in a way that is inconsistent with what the seller thinks ought to have been done. The buyer, for example, might have changed the accounting policies or changed some operating practices. So it's not that difficult to see how the parties could end up in dispute in that context. Third one on the slide, earnouts. So I expect that's a term that is familiar to you all. Oftentimes a way for the buyer to pay the seller a portion of the final agreed purchase price if the target company achieves certain milestones within a certain period. So usually looking at these as being accounting items, and therefore they can be quite difficult to define in the appropriate way in the arbitration agreement, and as I say, a fertile source of disputes. And then the final bullet, post-completion covenants. I mentioned those earlier. You've got clauses that will restrain the seller, non-competes, non-solicitation, confidentiality. Damages may not be an adequate remedy, and an injunction may be the relief that the buyer needs to restrain the seller. So I guess that's all I was going to say about the orientation of this. I want to move now. I just have 3 slides and then I'm done. Some practical thoughts, strategies, tips, many of which I expect will be very obvious to you all and you will know. I hope at least 1 or 2 may not be. So starting firstly with the arbitration agreement itself. This is headed this taking control of the arbitration agreement. We've probably all experienced situations, I know I have, candidly, on a couple of our deals in the past where it's really the transactional lawyers who have negotiated the general dispute resolution provisions in the transactional documents. They haven't come necessarily to people who believe that they know something about dispute resolution, and really that may miss an opportunity to take control of the agreement and put yourself in the best position to achieve peace and avoid the war. So you really, you of course need a watertight arbitration agreement. Most things will flow from there. You want to make sure that that agreement fits the circumstances of your transaction. If you've got a recognized set of rules, ICC, LCIA, whatever it might be, they may be too general, they may not be specific enough for your deal. So you have to be careful about that. If you're altering the model clauses, you want to make sure that the alterations actually fit, again, are specific to your deal. Many times, there might be a multi-party, the model rules adopted may not have provisions that are multi-party in nature. So if you've got a multi-party dispute and a set of rules that doesn't recognize that, that may pose some practical difficulties. Some more sort of truisms, I guess. Of course, you want to get the right arbitrational institution. You want to get the right rules, self-evident. You want to get the right seat. So you want the arbitration to take place in a jurisdiction where the national courts support arbitration. You don't want them to interfere, I would suggest, typically at least, in the conduct of the arbitration proceeding. You don't want them to encroach on the jurisdiction of the arbitral panel. Of course, you want to get your choice of substantive law right. Common law jurisdiction, if the arbitration agreement you feel puts you in a strong bargaining position relative to the counterparty. In a common law jurisdiction, that may be a very good thing because the parties might be more likely to be held strictly to the terms of the arbitration agreement. If you're in a civil law jurisdiction, then those terms may be more malleable. You may have an opportunity to improve your negotiating position if you're the party trying to improve it. That's because civil law, as you'll know, there are oftentimes general good faith obligations that are not present in common law jurisdictions. Reciprocity and enforcement, so quite briefly, of course, absolutely critical. If you get an arbitral award rendered and the award debtor can't pay, then you're going to need to go against that entity, against its assets. The New York Convention, which I think it's law in over 150-something countries now, that severely restricts the capability of local courts to interfere in the arbitration, which is a good thing, or can be a good thing. Moving through this, you want to get the tribunal right. Others have touched on this, I know. Do you want a single arbitrator? Do you want a panel? Do you want a black letter type lawyer? Do you want someone who's more, perhaps with a broader merits focus? Do you want somebody from a common law jurisdiction or civil law? If you get a retired judge from a common law jurisdiction, you might find you've got somebody who is keener on large-scale disclosure, and also on cross-examination of prospective fact and expert witnesses. You may not find that with an arbitrator from a civil law jurisdiction. I'm just going to skip down to the bottom one there about defining compensation measures. Yes. So the really important point, as a buyer, whatever the merits of the claim, you're only going to get damages if you can satisfy the contractual measure of damages. So in a common law jurisdiction, that's typically, to put the buyer back in the position it would have been in if the contract had been properly performed. I'm going to jump ahead now to my penultimate slide, if I can get there. Okay, so Vincent mentioned this. It may well be a familiar concept to you all. So, oftentimes we have found that M&A arbitration is somewhat skewed in favour of the buyer. There's an asymmetry of information. So what do I mean by that, and how does the asymmetry arise? Well, if you put yourself in the shoes of the seller, you have handed over all of your documents. The only documents you may have available to you pertaining to the target are the ones that you have copies of that were in the deal room. And given that we said earlier that, assuming this is right, that most of these disputes arise post-close, well, they may arise relating to post-close events. And in that case, you've got a whole bunch of documents that were in the deal room, and they may not help you very much in defending a claim brought by the buyer. The other, or one of the other things you have a problem with if you're the seller is your access to employees who are potentially relevant fact witnesses. So you're the seller, you've sold the target company to the buyer. I think you've probably got at least, probably two groups of employees. You've got the people who were sold with the business. They're going to owe confidentiality obligations to their employer, and most tribunals, well, you can make a disclosure request, but a tribunal may very well not allow that to override those obligations. So that's group one, and then group two, you have employees of the target company who may have been terminated as a result of the deal. And, well, let's say you want to get as a fact witness someone who was terminated as a result of the deal. They've signed a termination agreement. They've received a lump sum. The agreement they've signed has got confidentiality obligations in it. And if they breach those obligations, there's a clawback provision, and the lump sum they receive may be, they may have to reimburse it. So you can see with these things, as the seller, you could find yourself in a very difficult position in defending claims. You don't have the documents, you don't have the personnel. And the buyer does, potentially have access to the target employees and the documents. Just when the seller thinks that nothing could be worse, you also have to consider the position of the target. So if the target's not party to your arbitration agreement, it's a true third party for the purposes of your dispute, which is going to cause all manner of practical problems when you're trying to defend a dispute. So what can you actually do about it if you're the seller? Well, I think you can do quite a few things. Before you have executed the agreements with the general dispute resolution provisions in them, so the arbitration agreement, you've got opportunities to get your retaliation in first and prepare yourself for the war. So what might you want to do? Well, on documents, you probably want to write in broad disclosure obligations on the part of the seller, on the part of the buyer. You probably want the buyer to, if the target company is not a party to the arbitration agreement, you're probably going to want the buyer to procure, with at least a reasonable endeavours obligation, that it will get hold of, or try to get hold of, the target company's documents. So that's documents. We mentioned also employees. You're going to again want, as the seller, you're going to want to be in a position where you've got access potentially to those employees. You might need them to help you tell your story, defence of an arbitral claim. You're going to want the confidentiality obligations that those employees be waived, at least for the purposes of the dispute. I think those are the main points on this. Sorry, one other very quick point. If you haven't done all those things and your dispute has happened, you haven't got your retaliation in first, you haven't prepared for the war, is it too late? Possibly, possibly not. I think I've certainly had this situation where we didn't have all of those helpful things about disclosure and access to employees, but we did have a general contractual entitlement in a provision buried in the deal documents that gave us access to relevant documents, which we invoked and got most of what we wanted. You can, I think, also run fairness arguments to the tribunal. If the buyer is using the documents that they have that you don't have for the purposes of bringing their claim, then you're going to be wanting to say to the tribunal, well, how can that possibly be fair? We lack the tools with which to defend ourselves. The buyer's using those tools for their own purposes and not allowing us access to them. So you've got a fairness argument there. Just a final word on this slide, then I have one more slide and I'll hand over to Mark. As a general proposition, you may find that the buyer is trying to bring, it's throwing everything out there. It's trying to bring its action with multiple breaches identified, and many of those breaches the buyer, it probably hasn't even, truth be told, investigated, or at least not investigated properly. They're trying to bring the claim with a bunch of things alleged to avoid a time bar, which would otherwise preclude them from bringing the claim. So as a general proposition, if you're sitting in the seller's seat, I'd suggest you want to methodically, appropriately, aggressively have the buyer, force the buyer to prove each and every single factual assertion, each and every claim You may that way get rid of at least some of the claims early that the buyer hasn't properly investigated. Oops, 1 2 minute. There we go. Final slide. I've talked about the arbitration agreement. What else? What else is potentially relevant that you might want to think about? First bullet, full and effective due diligence speaks for itself. Critical. Second bullet, with some sub-bullets that are in even smaller font. So you want to use clear wording in your sale and purchase agreement. I mean, others have spoken about this. Again, it's very, very obvious. Ambiguity is the enemy. The parties are going to need to clearly allocate risk between themselves in the documents. And remember, if you're the lawyer writing up one of these documents, well, whether or not there's an independent expert determination provision whereby an accountant looks at the completion accounts, you might well have finance professionals, accountants, etc., interpreting the provisions about financial reporting, accounting, technical items that the lawyers have drafted. So I would suggest if you've got a mismatch between what you think that provision means as the lawyer and what your financial due diligence people working on the deal with you think, then you may have a problem. So, I mean, just for sort of round this off, I mean, Virginia had mentioned, we're talking about cross-border M&A, Virginia had mentioned cultural issues. I mean, you can't, I think it's impossible in most deals and most disputes to divorce those. I mean, it's just unreal to assume that, in my view. You've potentially got differences in legal systems informing people's perspectives. If you're coming at this from a sort of common law jurisdiction, then there's not going to be a general obligation probably for the parties to act in good faith. If you're the buyer, you're not going to have, or you're going to have very limited statutory and implied protections. So your philosophy is going to be, I think, well, I want all the warranties, representations, and indemnities I can humanly get out of the seller. If you flip that around in a civil law jurisdiction, there may well be that good faith obligation. So you may not have the same sort of push to get all those warranties, representations, and indemnities in. Just the final point is about pricing issues. Just two thoughts on this. I mentioned the lockbox mechanism. It's quite difficult to get evidence as to how often, or at least I found it quite difficult to get evidence as to how often the lockbox mechanism is used in preference to the completion accounts approach. Somebody else, I think you were using the same expression that I'm about to use, that if you're choosing a valuation mechanism for an M&A deal, a cross-border M&A deal, the tail cannot wag the dog. I mean, it just seems simply unrealistic to think that your entire valuation basis for the deal will be predicated on which type of mechanism puts you in the best position if there's a subsequent dispute. It doesn't work like that, at least in my opinion it doesn't, or shouldn't. That said, there's probably some reason to think that a locked box mechanism puts a seller, remember who's suffering this information asymmetry, puts the seller in perhaps a better position. Might be that the buyer, because you've got the lockbox mechanism, you haven't got this truing up of the completion accounts, you may find that the buyer is less likely to look at ways to try and claw back value. So something to think about if you're the seller in a deal, perhaps. And finally, and then I really will pass this over to Mark, volatility, potentially critical, in my view. Why? Because, well, I mean, there are real-world events that are happening. Your deal due diligence may stretch out for months, as we all know. The dispute may come a substantial period of time after the deal is closed, probably will. But real-world events have an impact on the deal price. You can have volatility. I mean, in our world, you can have pension obligations as balance sheet items. The present value of those obligations can change radically. Hugely important. The buyer thinks it's getting X plus Y. Ultimately the liabilities it's accruing are X plus Y. You can have large swings in the sale price for something that the target company sells that make the target, frankly, less attractive as a proposition. You could have, in some industries, kind of unexpected regulatory changes. So all of these things, if you've got a way, before everybody's signed off on the sale and purchase agreement, if you've got a way to define price adjustments that you can apply to address volatility, potential volatility, then I'd suggest you'd be well served to look at doing that. Okay, Mark, over to you. Thank you very much for listening. Over to Mark.